Welcome to another episode of Adventures in the East, a podcast by Kinstellar, leading law firm in Central and Eastern Europe and Central Asia. My name is Wochensky, and I lead our risk and investigations practice at Kinstellar, where I am a partner. Today, we are joined by two very special guests, Agnes Lackenberger. I pronounced that probably incorrectly.
No, that's fine. Thank you.
And Markus Taufner, also not great pronunciation, I'm sure. Agnes is a senior associate in our Vienna office. Markus is a partner in our Vienna office. Agnes is in the competition practice, and Markus is in our risk and investigations and dispute resolution practice. Thank you to both of you for being here today.
Thank you for having us.
Yeah.
Thank you.
So today's episode is slightly different than the other episodes that we have done. We are going to talk about cartels. So some of the questions that we're going to be talking about are, how do cartel investigations unfold? What is at stake for companies and their board members? Can directors be held personally liable for cartel fines imposed on the company? Can companies and the directors face criminal liability in cartel cases? And a number of other questions, which are very important for anybody working in the region. Now, this is a conversation primarily related to Austria, because that's where we are. Do you find any differences between investigations, either cartel or in general, between Austria and our other jurisdictions, Central, Eastern Europe, Central Asia, where you may have worked?
You know, at the end of the day, the topics for investigations and the investigations you do are quite similar. You know, the scope can be rather wide. You know, you can have as a scope GDPR violations, you can have like violation of competition laws, you can have like violations of criminal laws. So at the end of the day, I think irrespective of where you are in the region, the scope can be very different or very similar.
Correct. Yep. Sounds good. Yeah. Local issues are always going to play a factor, but people are people and investigations are investigations, investigating a lot of the same things. So, yep. Okay. I would like to start with you, Agnes, by asking a question for, because we have a lot of listeners who are maybe not attorneys, and even some attorneys who are not extremely familiar with competition law. Can we start with just a basic question? What is a cartel?
Yes, sure. In principle, the cartel ban concerns all agreements and all concerted practices by undertakings with the object or the effect of restricting competition. Mm-hmm. However, the cartel ban only constitutes one pillar of competition law. The other pillars of competition law are the abuse of market abuse and power and the merger control rules, which have to be obliged.
So the point of competition law, right, is to ensure that our markets remain fair. Correct?
Yes, exactly. And I mean, the ultimate goal of competition law is to protect consumers and keep prices fair.
And so a cartel, in that sense, how would that make the market unfair?
One example one very recent example is bid rigging, mm-hmm. where different companies colluded different bids, and so it was not possible to get the best price for the bid.
So the two companies would then illegally contact each other, agree on a higher price, mm-hmm. and that would be detrimental to the procurement authority or
exactly
the government.
Yeah, so it would cost all the consumers in the end, as not the best offer would get the bid, but the one where the companies already colluded about.
Right,
yeah.
Right. And so who is responsible for policing that cartel and other activity?
I mean, in principle, it depends if it's on a European level or if it's on an Austrian level. Mm-hmm. In Austria, if it only concerns the Austrian territory, the National Competition Authority, the BWB, is responsible for conducting these investigations. Yep. However, if you look at it from a broader scope, the European Commission is responsible for conducting such investigations. This, in fact, is, however, also different to the criminal investigations, which can also play a role, especially when it comes to bid rigging.
Okay. And are companies subject to criminal liability in Austria as well, or just individuals?
Markus, do you want to take this question?
Yeah, sure. So in Austria, we have the concept of corporate criminal liability. So it's not only individuals that can be held criminally liable, but also companies. And the companies are criminally liable for the misconduct of its decision makers, which includes directors, for example, and also its employees under specific circumstances. So the risk is not only risk exposure not only for the individuals, but also for the company. And here you have fines of up to 2 million euros.
Okay. And so you have risks for a number of different people, right? So if there is a competition violation, you have risks for specific individuals who are working for the company, directors of the company itself, and I assume, and sometimes that'll go up to the parent company as well, perhaps liability could even jump to the next level.
You have to take into account here that if you consider fines in cartel law, you always have to think about the group turnover. So it's not only subsidiary, which is perhaps located somewhere in Austria, but you have to think of the whole group. And if you take this into account, these can lead up to very hefty fines. If you think about that, the fines in cartel law can amount to up to 10% of the annual group turnover.
Turnover, right? Not profit, but turnover.
Turnover, yes.
Yeah, that could be a pretty big amount.
Yes.
Sure. Yep. Okay, so we know that there's an authority or authorities that are responsible for monitoring this activity. What would generally start an investigation into a potential violation? So how would an investigation start, basically?
Well, there are very different sources for the first investigations. One of the most common one is, of course, to have a complaint by a customer or a supplier, which is not really happy about high prices for their products. Another possible source is whistleblowers and sector inquiries. The Australian Competition Authority is increasingly doing exactly these sector inquiries in order to also kind of fasten their investigations in the future and already have enough information before. And one of the most important other sources for investigations are, of course, leniency applications. Leniency applications in Austria basically constitute in a participant in the cartel who is actively seeking to be removed from a fine in order by already explaining the cartel, giving proof and giving information about the cartels and the participants of the cartel.
So this is if a company or an individual has done something wrong, they're able to self-disclose that violation, and in exchange they receive some sort of leniency.
Yeah.
So something like a deferred prosecution agreement in the U.S., but different because it's in the EU.
Yeah, and also you have to take into account that firstly, you can either have the whole fine removed, or you can get a reduction from the fine if you deliver additional value to the investigation, which fastens the proceedings. Yeah.
But also the requirements of leniency programs are very strict. So there has been a recent case in Austria where there was like an leniency program, and everyone thought things are going fine. And then the Austrian Supreme Court actually lifted the decision and said, we go back to the start and we might need to increase the fine. It was, more or less agreed upon.
Because you need to have the full disclosure here and really show all the information you have and all the proof, and not withhold any information if you want to go the authority.
So this shows that the threshold, to reach like the benefit of leniency is very high in general.
Right. And it's important to engage external counsel for this exercise.
Absolutely.
So there's various ways in which investigation gets started. One question I wanted to ask about that is for a whistleblower. If there is somebody out there who has seen wrongdoing, I would think that there would just generally by human nature be pushback against that individual for whistleblowing about some sort of cartel. How are the protections in Austria and the EU for whistleblowers to ensure that there's no pushback from anybody else?
Whistleblowers get full protection, of course, and everything they deliver to the authority is confidential. But you have to consider that, I don't know the numbers right now correctly, only a very limited amount of the whistleblower complaints actually leads to investigations.
Okay.
So that's really a very helpful source for starting if you see it in context with the leniency applications. The leniency application is much more thought has been given to why you want to conduct investigations here. Whereas with whistleblowing applications, sometimes you have a very unhappy customer who says, maybe we have a cartel here or market abuse. Market abuse is super, super popular with customers. But in the end, it's very hard sometimes to really prove that there was an abuse of market abuse.
Right.
And the number is really low. The number of whistleblower complaints in 2024, I think, was around 90. And after an intern, like a first assessment by the competition authority, like 75 of them were actually dismissed and as seen as irrelevant.
Yes.
So the number is rather low in Austria.
So in most of the cases, it is a voluntary disclosure that's starting the action. Yeah. Okay.
Mostly. Yeah.
And are there cases, I assume, where one of the cartel participants disclosed and the others did not?
Yes.
Yeah, of course.
These are the leniency applications.
Yeah. So the leniency is given to the disclosure.
Yeah.
And then the other participants are subject to the full.
Yeah.
Exactly. So this is why it's so important to be actually the first one, because you can set a marker at the competition authority, and then you have the chance of being granted leniency.
Yeah.
And all the others are subject to prosecution and
It's like the
proceedings.
prisoner's dilemma.
Exactly.
But you have to be super fast when you think about leniency. When I think about one case, which is quite recent, it needs to be, if you think about, okay, now you have the first person who is applying for leniency, the other undertakings, usually they also want to be granted the leniency within a few days, because the sooner you are, it makes a huge difference if you're the second or the third or the fourth person. If you think about the reduction of the fine, which can be very, very substantial.
So, is there a way? Let's just say that I have committed some sort of violation, but I want to conduct a full investigation. And I'm concerned that the other cartel members will also disclose. Is there a way that I can disclose without having that full internal investigation, and then given some time to conduct the investigation, or is that generally not how it works?
Generally, you can do an audit before. That would be also very much recommended. And it can also be very much recommendable to already prepare a leniency application. So if you know already that there will be perhaps another cartel participant who will go to authority, you don't have to go to a lawyer in order to investigate and make written statements, etc., but to already have all the proof more or less in your office.
So you're making the job the easiest for the authority.
Yeah.
Right? Yeah. Okay, good. So we've established what can cause an investigation. We've spoken a little bit about the consequences, but I'd like to get into that a little bit more. What are the sort of the general outcomes? What can happen in a cartel case? What are the risks that companies are facing? We spoke about fines. Maybe speak about that a little bit, and what other risks that may be out there.
I mean, the most important sanction is, of course, the already discussed fine. I mean, we don't have this in any other area to have the 10%, even if it's hardly ever reached, of the annual group turnover, and not just the profit, as already discussed.
Yeah.
And we can see that recently the competition authority have really leveraged their potential here. In a recent case against a retailer, the cartel court initially only assessed a fine of 1.5 million euros. However, the Supreme Court increased the fine up to 70 million euros.
So from 1.5 million to 70 million?
70 million.
Okay. And you said that there's a separate cartel court in Austria?
Yes. I mean, it's within the civil court, but you have special persons there who are...
It's with the Senate.
A Senate, yes. Yeah.
Yeah. Is Does the court have investigating ability like in France, the investigating judge?
No, that's a huge difference. We have the investigation authority in Austria is only
That's the BBB.
It's BBB, exactly, the Austrian Competition Authority. However, fines and other sanctions can only be imposed by the cartel court and can be, as the case we already discussed, overruled by the Supreme Cartel Court.
So your first step is to try to come up with some agreement with the BBB
Yes.
as to the fine.
And we can see from this very harsh cartel fines that it's often the most advisable approach to settle with the Austrian Competition Authority for a reasonable fine. Otherwise, the Supreme Cartel Court may overturn the decision by the Cartel Court in order to get the deterrence, which is very much the importance of the Supreme Cartel Court, that you have deterrence, and the Competition Authority may see this a little different, and you have more leverage with the Competition Authority. You have negotiations, and you can talk with them quite easier than with the Supreme Cartel Court, of course.
Right.
But the problem also is that you don't only have the competition proceedings, you can also have the criminal proceedings, in case of bid rigging. So if you settle the case with the competition authority, you still have like the criminal authorities that you need to deal with. And here it's important to emphasize that the corporate fines, the criminal fines that can be imposed on the company, will be added to the fines by the competition authority. So you have like a really high risk exposure, not only by the competition proceedings, but also criminal proceedings.
And is it the same type of situation that you can voluntarily disclose to the criminal authorities, or?
Yes, it's the same concept actually, also in criminal proceedings. Exactly.
Yeah. Okay. And the fines are similar in amounts? Or?
They're capped by 2 million euros. So they're not as significant, but 2 million can also be, a huge amount of money for certain companies.
Yeah.
And what's also, as the risk following a cartel is also from a litigation perspective, as soon as a company actually got fined by the competition authority, the risk of follow-on claims arise where, parties that were damaged by the cartel actually filed damage claims against the participants of the cartel for the compensation of such damage. For example, the overcharge they paid for a cartelized product or service.
Right.
And over the last few years, we have actually seen an increase of the number of these follow-on claims, or it's also called private enforcement, which may also be contributed to the involvement of litigation funding firms. They're like firms like that team up with law firms that represent claimants and that then fund the claims against the participants of the cartel.
And are you able to probably make your claim much easier? You can just use the results of the investigation from the either criminal authority or the BBB to just submit together with your civil liability claim, or do you have to reprove the amount of damages and the initial violation?
There are certain procedural privileges that they have in such kind of proceedings. So, for example, you can file as a claimant, you can file an application that the defendant, the participant of the cartel, is actually obliged to disclose certain information and certain documents, which can be a very, very powerful tool in jurisdictions just like Austria, where you don't have, US-like discovery proceedings or similar proceedings. So you're somehow have an easier case as a claimant in follow-on claims.
Sure. One last question. I have to imagine that participation in public tenders is very important for a number of different companies, in construction industry or anything like that. There has to be some sort of reputational and maybe even a statutory risk of participation in further tenders if someone is caught for participating in a cartel. Is that true?
Yes, that's true, and that's very
yeah.
much a risk. You can be held not reliable and be excluded from the tenders. And this very much is, for many companies, a huge risk if they are working in the public sector.
Understood. Thank you. So we've spoken about the risk for companies, which is primarily our client base. But there's individuals obviously involved in the activities, in the violations. And there certainly has to be some sort of risk that the individuals face as well, correct?
Mm-hmm. I mean, it differs from jurisdiction to jurisdiction. For example, in Austria, we don't have individual fines for cartel abuses. However, in Germany, we do have such. And also there's, of course, the risk of civil liability, which always has to be taken into account. Moreover, at the moment, there is a case pending before the European Court of Justice with exactly the question if the managers can be held reliable for cartel abuses. So if it's possible that that the company can have some sort of regress from the individual who has conducted in the cartel. However, right now the case is still pending before the European Court of Justice and will be most likely handed down in 2026.
Yeah, but it's a German case. It's related to a steel cartel where a cartel fine amount of 4 million was imposed on the company, and the company now claims compensation of damages from the director that was involved in the participation of the cartel. And it's also very interesting to look actually in the decisions of the German lower instance courts, because they actually dismissed the claim. They did not hold the director liable for cartel fines. And the main argument that they used for the dismissal was actually that they said, the purpose of the cartel fine is actually to deter companies from the violation of competition law, and it would be against this purpose that the company can reimburse the damage from the director, because then the financial burden of the fine is not ultimately borne by the company but by the director. But you also could take a completely deviating view, because you have to consider that the company is represented by the director, is managed by the director, and the director is also responsible for ensuring that the company is compliant with the law, which also includes, of course, competition law. So if the director doesn't need to be afraid of compensation claims filed by the company for violation of competition law, then the director is actually not deterred from participating in a cartel, because due to the lack of legal consequences for doing so. So you see there are a lot of arguments pro and against this liability of directors for cartel fines, which is why the decision of the ECJ is very much anticipated, especially by Agnes and me. And will bring, much needed clarity in this regard.
That's really interesting. So, and is there anything that either a director or a company could do to try to shift that liability to sort of protect themselves from the fine at this point, without the decision being held? Is there anything that a company can do?
The best thing to mitigate and manage risks in law in general is to have an effective compliance system in place that is really, applied in practice and embedded in the corporate culture of the firm and doesn't only exist on paper. So in cartel matters, for example, it can be a valuable tool to have also employee trainings, that the employees that deal with these kind of agreements, negotiations, are actually aware of the legal risks. And what can also be helpful is that you have some kind of a protocol or guideline for dawn raids that you can take out when the authorities are knocking on the door, to have something to hold on to in such a stressful situation.
So obviously, yes. I mean, I think when we talk about compliance programs, the best way to avoid fines and reputational risk and other consequences is to not commit the violation in the first place.
Exactly.
However, individuals are individuals and they have their own individual interests and act in certain ways. Does a proper compliance program assist a company even if an individual is not compliant with that compliance program? So is there leniency given to a director in a company if they've been doing everything right?
Yeah, the compliance measures and the improvement of the compliance system afterwards, after the violation, will be duly considered by the authorities.
Mm-hmm. Okay.
So, from the perspective of the company and the director, a D&O, a directors and officers insurance, can be a potential safety net. Yeah? So this kind of insurances work the way that they provide coverage for damage claims raised against the director for the breach of managerial duties. Yeah? And if you think about the violation of cartel law as within the scope of managerial duties, the scope of the duty of care of a director, it could also be that these D&O insurers provide coverage for damages resulting from a cartel. Of course, this depends on the specific terms and conditions of the D&O policy. And, as a director, it's always,
Sure.
and you need to check whether this is covered or not.
Right. Yeah.
Maybe as a last resort in regard to how to mitigate risks, there's always this last resort of leniency applications. But as already discussed, these leniency applications, they do have also risks. Firstly, you have to really provide all information and all proof you have. Otherwise, it is possible, and it has been the case recently, that the case is reopened and the fine is significantly increased. Further, you always have the risk that if you are lenient and if it's public that you have been involved in a cartel, you have the reputational damages. And also in regard to the follow-on damages, it can be advisable to really think about if you want to do the leniency application or not.
Right. Yeah, no, a lot to think about, and that's why we have specialists like you. You had mentioned a term, and maybe not everybody in our audience is familiar with it. You had mentioned dawn rates. Can you let us talk a little about what is a dawn rate?
Well, very funnily enough, dawn rates are called dawn rates because usually they are very early. So this is a situation where the authority knocks at your door at 7 or 8 p.m. and says, now, we're doing an investigation because there's this concern that a cartel has been done in this area, in this market. And then they call the lawyers usually, and the lawyers come in a little later, not so stressed usually, not as stressed as the companies. And the competition authority tries to gather all information they need in order to conduct their investigations in regard to the cartel. Usually as a lawyer, there's limited you can do during the dawn raid. I mean, you can protect what is protected from attorney-client privilege, for example, and there are certain other rules the competition authorities do have to oblige. But mostly your job as a lawyer in dawn raids is to assist the companies and to really help them to explain what comes next and to gather the information together with the authorities already.
Right.
But it's really interesting how diligently these companies often, write down the agreements that they have with other competitors. Yeah. So there's the story of the red binder found by in the course of a dawn raid, which then triggered the whole investigation. So that really happens actually in practice. Yeah.
It's very different from anti-corruption investigations. And anti-corruption investigations, there's very rarely a receipt given for a bribe.
Exactly. Yeah. Exactly.
Whereas here, the companies are agreeing with each other.
Yeah.
That's
very bluntly sometimes.
Yeah.
So, are there any limits as to what the authorities? I assume it's the BBB that comes in and does the investigation. Is there any limit as to what they're able to take or not take, or do they have pretty vast authority to?
They can
hard drives, phones,
basically everything, and then the cartel court can decide if certain elements have to be excluded because it's not really relevant. But the authority can take basically everything with them except the attorney-client communication, of course.
Right. Are there any cases where they would, instead of a dawn raid, request disclosure from a company, or is that not usual practice?
Not really, and maybe to have here the full picture. In order to be granted full leniency by law, you have to provide sufficient information for the dawn raid. So the dawn raid logically is the second step.
Understood. Now, One of the things that we do in other jurisdictions is that we get scary people like me to come in and pretend that we're the competition authority. Is that something that is frequent in Austria as well?
Yes, we also do mock-down rates here.
Mock-down rates, yeah. And
So you love that, I guess.
I
It's 7 a.m. Good morning.
think that says more about me than dawn rates, but yes, that is an interesting exercise. Much more amusing for me than being on the other side when we get a call. Real dawn rate and for our clients, for sure. Yeah. So as a way to protect a company could hire a law firm like Kinstellar to conduct a dawn rate to understand what information is out there. Now, when you do that, are you looking for violations generally, or is the main goal just to make sure that the company is responding correctly?
I mean, both. I mean, the most important thing is to keep calm and to already have, as for example, of the dawn rate guidelines, a procedure the company follows. And if you test it beforehand, you will be much calmer if it really comes to an investigation by the National Competition Authority.
Sure.
But if there's like a slight suspicion that there is some kind of a cartel and some illegal agreements going on, then what we do is we perform internal investigations and we get to the core of it and find information and documents to find out about that. Yeah? And then, of course, this information that we can gather in the course of an internal investigation can also be used then for leniency applications, of course, to be the first one that is not eventually fined or to reduce the fine. Yeah? So from this perspective, these investigations and, hiring a law firm for that is very important.
But in addition to government investigations, internal investigations are a major part of our practice area.
Exactly. Yeah.
In which we understand what is the actual information out there, and then the company, together with us, is able to decide the best path forward to mitigate any risks and to make sure that the company is continuing to operate properly.
Exactly.
One other question I had was in relation to employees. So if there is a cartel and there are certain employees that are responsible, understandably, I would imagine that companies would like to move on from those employees. Are there any complications in Austria when you have an employee like that? Does the employee need to be found liable for the cartel? Is there anything in employment law that would prevent the employee from being terminated? Anything you have to say about that?
In Austria, general employment law applies. So if you as a company find out the employee was actually engaging in such kind of illegal activities, then you have a cause for dismissal and can end the employment with immediate effect.
Yeah, it's interesting, important for U.S. clients who are used to at-will employment, where you can dismiss for really any reason. That here there does need to be a reason to dismiss. At what point does there have to be a judgment that's handed down, or is it sufficient to have a suspicion?
Suspicion suffices.
Okay. Which is different from a lot of our other jurisdictions.
Yeah.
But the problem is if the employee then files a claim for unjust dismissal, you as a company, as a defendant, have to prove actually that this reason, this cause for dismissal was actually existent.
Yeah.
So you have the burden of proof.
Right. And a lot of times those claims do happen because employees do not want that on their record.
Absolutely.
Yeah.
Absolutely. Yeah.
Competition law has been around for quite some time now. Do you see a tendency in Austria or around the region? Are there more and more cartel cases? Are there less? What do you think the trend is?
I mean, generally in Austria, one has to highlight also the construction cartel. If you think about Austrian cartel law, where fines of up to 193 million euros have been imposed due to the cartel which existed from 2002 to 2017 within all Austria. And if you think about that, the Austrian Competition Authority was only introduced in the 2000s, early 2000s. They have done they have set increasing fines recently, and they have been very, very active. And especially given the global landscape, not only in Austria but also the European Union's fines are increased, and market participants have to be very wary of their conduct.
Are you aware, is there any information sharing between the Austrian authorities and the European or authorities in other countries? Are they sharing information about potential competition cases?
Yes, there's cooperation between the ECN Plus network. Yeah.
Okay.
Also in criminal cases, of course.
Yeah. And if you think about the digital sector, for example, the European Commission is responsible with the DMA, for example, and the Austrian Competition Authority does see its role more in a cooperational setting than in an investigational setting, which makes sense given the broad scope, of course.
Right. Well, we had mentioned a couple industries, talking about construction, digital. What do you think are the the industries most susceptible to violations to cartel violations?
I think, from my perspective as a litigator, you're the competition expert, but I do think there is no restriction, actually. I read all the reports by the competition authorities, and, it extended to, to escalators, to trucks, to food sector, to everything. So,
I mean, that's true, of course, but the competition authority does really emphasize its highlighted scrutiny on the food and on the energy sector, as these are consumer goods. And everywhere where the consumer is very easily harmed, the competition authorities is even more wary.
Right. Interesting. Well, I think that it's important for companies and individuals to understand the risks. Obviously, compliance programs are extremely important for any company to have, including in relation to the potential for cartels. Dawn raid exercises are important. There's a lot of other things that companies can be doing to make sure that they are mitigating the risks in this area. Internal investigations are important if there is a potential violation that a company becomes aware of, especially in cross-jurisdictional matters, and generally, things are going to happen. So it's important to have very good legal counsel in those jurisdictions if that does happen, regardless of any compliance program that may be designed very well, but still individuals are individuals. So we'll continue to monitor it. I would say everybody should maybe sign up for our newsletters and updates at Kinstellar to keep aware of all of the updates in Austrian and European competition law more generally, and criminal law as well. With that, thank you for joining us, and we will speak with you next time. Again, this is Adventures in the East, a Kinstellar podcast. Kinstellar is a Central East European and Central Asian law firm. I am Wochensky, and I'd like to thank Agnes Lackenberger.
Thank you, yes.
And Markus Taufner.
Thank you so much.
Me today here in beautiful Vienna, and now we're going to go out and enjoy an espresso on St. Stephen's Square. Is that the...
Perfect, exactly, yeah. Thank you so much.
Thank you.